practice in criminal law in Dallas, Mike Rodgers. I try to ask all my clients in the first visit, what is it that you want out of the case? And in the early days of my practice, most people would say, well, I want to get probation, or I want to get, I don't want to go to prison. Or the best thing they could say is, I want to clear my name, which indicated to me that they either believed they were innocent of the crime, or they believed I could get a jury to believe they were innocent of the crime. Either way, it showed a determination on their part to see the case through to the end with an expectation of a probable victory. That just doesn't happen much anymore. Today, instead, what I hear more than anything else, I say, what do you want out of this case? What do you want me to do with it? And the most common answer is, I want it to go away. Can you get it dismissed? But the best movie about what really goes on in court is My Cousin Vinny. In the early, I think it's during his first court appearance representing the two, his cousin or his nephew and the cousin's friend, the nephew's friend, in this capital murder case down south. He's basically telling the judge that they're here because of a mistake, and the judge starts to get frustrated. And finally, the judge says, well, you know, we're not going to skip the whole procedures of the state of Alabama just because you find yourself in the unique position of representing clients who say they didn't do it. You know, basically what Vinny's trying to ask the judge to do is just dismiss the case because it's a mistake. A lot of clients and prospective clients think that's correct procedure, to just get it dismissed because they didn't do it, or they've got a good reason why they did it, and it's really not a crime. That's not grounds for dismissal in any court, Alabama, Texas, or the United States federal district courts, and cases don't get dismissed that way. Let me tell you how cases actually get dismissed, and this one has a unique twist to it that I've never seen it happen like this before. But I'll briefly tell you the facts of the case, and I'm doing this, by the way, with the full consent of my client. He's quite happy with me right now, and he's willing to let me tell his story. I'm not going to use his name, but he's willing to let me tell the case to my clients through these videos. Here's what happened. This guy came to me probably a year ago. His case had been going on for about a year at the time, and he'd been to court many times. He was charged with assault, family violence, and the actual facts of the case were he had an apartment, a girl that he knew in the apartment complex who he would talk to in the afternoons when he got home from work, lost her apartment, and she moved in with him. He says that she wasn't his girlfriend. She probably told the police that she was his girlfriend. But it doesn't matter if you're living under the same roof or in the same apartment. For purposes of the assault statutes and the family violence protections that are provided under Texas law, that's a family member when you have an assault on somebody that you live with. So he was charged with assaulting her by pushing her into a door. By pushing her into a door. He came in, he said he was not guilty, he wasn't going to plead guilty, he was in fact going to fight the case, and he had just stuck with that story throughout many, many court settings. Interested in wanting a trial, and because we kept asking for a trial and the prosecutors wouldn't let us do it and the court wouldn't let us do it for reasons that are unimportant here. It was not our fault, it was the DA's fault that they couldn't come up with the discovery for a long time. But the point is that they knew that I was coming in with him on a regular basis and insisting on a trial. So they finally offered to dismiss his case if he would take anger management. He wouldn't have to plead guilty. He would not have to be placed on probation. He wouldn't have to pay fines or court costs. He wouldn't have to do community service or report to a probation officer or pay probation fees. Lots of money, lots of time involved in that. All he would have to do is take a 6-month course where he goes twice a week at night for a couple hours. So it's about 4 hours a week, I think, for 6 months. And then at the end of that, if he successfully completed that program, his case would never even go to court. In other words, they give us basically a 6-month continuance during which time he'd have to take the course. And he said, okay, he was going to take that deal. And I said, that's a good deal because you don't have to admit any guilt and you don't have to be on probation. So we were going to come back and tell them what course we'd signed up for, which of the anger management courses. And meanwhile, he lost his job, and he didn't have a way to drive around. He didn't have a driver's license for reasons that are unimportant here, but he had an identity theft at some point, and it was just impossible for him to get his driver's license. So he didn't have a way to get to the course. And his boss, who had been bringing him to court all these months, couldn't take him at night twice a week to do the anger management course. So we had to come back, and I had to tell the prosecutors that the deal was off. We wouldn't accept a dismissal in the case because we couldn't do the anger management. And the prosecutor said, well, if we have a trial and he's found guilty, he's convicted, and what is the judge going to do? Put him on probation and order anger management. So he's going to be back in the same boat, but he'll have a conviction. I said, well, that's just the way it's going to have to be then, because we can't take it as an agreement. So we set the case for trial. Finally, they set it for trial. And when we showed up for the trial, ready to go, worked all weekend on it, got him ready to testify, walked into the courtroom, and I said, we are ready to go in this trial. And they said, well, you're probably going to like this. We're going to dismiss the case. Now, that's how that case got dismissed. And the reason for the dismissal was that the woman who was allegedly assaulted decided she didn't want to testify. Now, that confirmed his story to be that he didn't do it and that she was lying to the police. And it confirmed he felt really good. And, of course, the great thing is now he gets a dismissal and he doesn't have to take anger management. So he gets out of the whole deal. It's over with. And that's how dismissals happen in Texas, at least in my experience. It's very rare for a defense lawyer to be able to file a motion to dismiss the case and have it granted. There are circumstances under which it can be done. It's provided for in the law, but you can't use the excuse like my cousin Vinny, which is, this is just a mistake, Judge, just please dismiss the case. It doesn't work. You have to have real good, serious legal grounds to do it. The way you get a dismissal is to force the prosecution into a trial situation and put them at the trial date where they can't go forward, or they're sufficiently convinced that if they do go forward, they're going to look bad. And under those circumstances, they may dismiss. An even better result there is if they can't go forward and the judge makes them go forward and announce for trial and call their first witness, in which case the judge will find you not guilty, which is, in my opinion, a much better solution. Because you can get a not guilty expunged, whereas a dismissal you can only get sealed. But we'll talk about that in other videos that are coming up. If you're still watching this video and you're not a client of mine, or otherwise have been invited to watch this video, then you really do need a hobby. You should take my advice, go to hold'emradio.com, learn how to play poker free. You might even get into some trouble there, and if you get in some trouble, make sure you get caught. And when you get caught, call me. Thank you. Bye. See you later. Oh, I'm not going to say Mike Rodgers. You've got it plastered over the screen, right?